Good afternoon, welcome everybody, and thank you for joining the BSGCT Early Career Researcher Seminar Series. I'm Carly Bliss, and today we have the huge honour of welcoming Rhian North from Cardiff University, who will be telling us everything we need to know about protecting and commercialising our academic research. First up, we'll go through a few housekeeping rules. So if Rhian, you could share your screen, and we'll just quickly go through how you can all submit your questions for the Q&A at the end of the session. So you're all tuning in via YouTube, and you'll see the live chat box at the right-hand side. So you can enter your question into that live chat. You will need to sign in either using your YouTube or Google account to join the channel. Your questions will not be private, so please be aware of that. Please include your name and your affiliation with your question, and at the end of the talk, I will pitch those questions to Rhian. So the earlier you submit your question, the more likely it is I will ask that question. I will ask them in order. If you have any problems with that live chat function, you can submit your questions to the email address shown on screen at the moment. So to welcome Rhian, thank you very much for joining us. Rhian is a Senior Technology Transfer Project Officer at Cardiff University in Wales. She works in the Biomedical and Life Sciences Technology Transfer team in Research and Innovation Services, where they aim to drive innovation, intellectual property and impact by transferring research outputs into a commercial arena. So Rhian has a significant amount of experience in intellectual property and research commercialization. She works to identify potential innovative opportunities. She then assists in their development towards impact and commercialization and guides on their translation of funding. All of Rhian's work is underpinned by a really strong background in science. She did a BSc and a master's in biomedical sciences, which I'm sure really helps her understanding as us as scientists trying to translate our work into that commercial arena. I've worked directly with Rhian and can attest to her breadth and her depth of knowledge in this area. So I'm sure you will all learn something new from her seminar today. And please, ask your questions early. I'm sure questions will come up as you can relate to your own research. So Rhian, thank you again so much for joining us. The floor is now yours.
Oh, perfect. And thank you so much, Carly. A very kind introduction. But yeah, as Carly mentioned, I am a technology transfer officer at Cardiff University. And what we're going to have a look at today is how you guys as researchers might develop intellectual property from, I know some of you might be PhD students or postdocs, early career research. And how we actually go about translating and commercializing that. So it might be a good idea, as we're sort of going through everything, for you to have a think about how this might relate to the work that you're currently doing or planning on doing, and sort of how this intellectual property might sort of feed into your current work. And so just as a quick caveat, obviously I'm from Cardiff University, so there might be some references specifically to us, but I'll point out perhaps where that is the case, and then who you might be able to go to as contacts within your own kind of university or institution. So first off, I'm going to have a quick background to what actually is intellectual property, the different types of IP that exist, what we refer to as this technology transfer process, and then how we actually go about commercializing any research that we might be involved in. So what actually is intellectual property or IP? I probably use the two terms interchangeably. Some of you might already be aware of this, but intellectual property is the product of thought, creativity, and intellectual effort. So it's essentially something tangible which you can own. So its ownership is sort of no different from owning something like a house or a car, in that you can sort of buy it, let it, sell it, rent it, or even borrow money against it if you're quite confident in your research. So the way in which we protect our intellectual property are referred to as sort of intellectual property rights, or IPR. You may have heard that referred to as previously. And as I said, intellectual property rights are the way in which you can actually protect any intellectual property that you may generate. So before we actually go off and look at these different types of intellectual property in more detail, I just wanted to quickly show you how the sort of main categories in which they fall into. So intellectual property, so this covers aspects such as patents, registered designs, registered trademarks, copyright, and then unregistered designs and trademarks, and know-how. And as I said, they fall into these two main categories of registered versus unregistered. So obviously, as the name kind of suggests, these registered types of intellectual property, you actually have to go out of your way to file these with the relevant intellectual property office, which for us here in the UK is the UK IPO, which conveniently happens to be in Newport, Wales, so just down the road from us. So essentially, registered intellectual property, as I said, are these things like patents, designs, and trademarks. And essentially, you will go to the UK IPO and say, this is my patent on this new drug I've developed. And they will essentially give you like a receipt back to say, you know, as of this date, you filed this patent. So, and same with designs and trademarks as well. So people see that as quite legally standing because you've essentially had a sort of time-stamped receipt from the government for this. But obviously in formally registering your intellectual property rights, you actually have to pay to do that. And you also have to pay to maintain it. So it kickstarts this kind of expensive, in a way, process. So if we look at the other types of intellectual property, so these are the unregistered forms, and this essentially means that they are automatically generated and you do not have to go out of your way to sort of file them as such with a relevant intellectual property office. So this can be things like copyright, unregistered designs, unregistered trademark, and what we refer to as know-how. And obviously, again, as the name suggests, you're not registering that with a governing body as such, so you don't have to pay any registration fees or any sort of renewal or upkeep fees. So there might be reasons as to why you'd go for maybe an unregistered type over a registered type, particularly for obviously designs and trademarks because they cross these two barriers. And this might be, so say if you've designed a new microneedle, but you haven't sort of locked down your final design. And you might say, well, I don't want to register it just yet because I don't think this is going to be my final iteration. Obviously, when I start doing further work on it, it might change. So you might keep that as an unregistered design until you think you finally lock that design and then you want to register it. Similarly with trademarks, you find sometimes people will call their products a certain name, but they're not entirely sure if that's the name they want to lock into. So they'll keep it as an unregistered and then perhaps later on follow up with a registered trademark. So yeah, before we actually, again, get into the core part of this, I just wanted to sort of outline for you something which is quite important. So IP ownership. So who actually owns any intellectual property that is being generated? So according to the 1977 Patent Act, an employer will own any IP generated by its employees. So myself as an employee of Cardiff University, any IP that I generate is owned by the university. Similarly, if any of you are sort of postdocs or early career researchers and you have an employment contract with your institution, your intellectual property is owned by that institution. And Cardiff and other institutions as well has this kind of agreement in place with its employees, whereby, say, Cardiff or whichever institution that you're part of decides they want to exploit or commercialize the intellectual property that you've generated. They generally have what's called a revenue sharing agreement or a revenue sharing policy with the inventors, which kind of shows how money is split. And this is obviously in reward for obviously your hard work in actually developing that intellectual property in the first instance. So as I said, this one is, the table is sort of specific to Cardiff University, but I'm sure that you all have a similar kind of framework in place as well for you to take a look at, which I'm sure is available on your kind of intranet pages. So one caveat that we do have is that if any of you are students, including PhD students, so you guys are not considered employees of your institution, you don't have that employment contract. So any IP that you generate is actually owned by yourself as an individual and not your institution. And what we do in our institution at Cardiff, and again, I'm pretty sure it's similar with other institutions as well, is that what we would say is that if we had a student inventor on a patent, we would say to them, assign your rights to us as a university, and then you'll be treated in the same way that an employee would be treated. So you'd be treated the same as everyone else, and you would fall under this IP sharing revenue policy that we have. And generally, when PhD students do contribute to intellectual property, that is obviously perhaps alongside their supervisors who have also had a significant kind of say in the project. And what this means is obviously the student owns part of the IP, and then the university does, which is why we do that assignment. But yeah, I think it's probably worth you discussing it with the teams relevant to this within inside your institutions to see what their kind of stance is on that. But I would say it's generally the same as well. So there are some other instances that we need to think about who owns the intellectual property. So we've obviously had a look at students, but also what we tend to look at as well is, are there any agreements in place which outline or govern who actually owns this intellectual property? So are you collaborating with another institution? Is there a collaboration agreement in place? Have you received materials from elsewhere that are not owned by you? And that MTA might govern who owns what. Similarly, if any of you have an industrial sponsored research or PhD, that will also determine who owns the intellectual property. And we do always say, obviously, we have to figure out who owns any intellectual property right at the beginning, because obviously it can cause a bit of issue if you figure out later down the line that you don't actually have or own all of those rights as an institution to commercialize this research. And I've mentioned a few kind of agreements that you would need to have in place. So just to quickly sort of touch on that. So common agreements that we put in place would be something like a non-disclosure agreement or a confidentiality agreement, and they're the same thing, just different terminology. And what this is a legal binding contract between two different parties, so perhaps two institutions or an institution and a company. And essentially this legally binding document will state that if you disclose any information to that other party, they are legally obliged to keep that information confidential and can be liable if they do not do that. We mentioned material transfer agreements, or MTAs, you might have heard them before. And this basically agreement allows you to transfer your materials to other institutions or receive materials from other institutions, in order to carry a specific piece of work. And again, the terms of this MTA will govern who owns the starting materials, who own the results, and things like, are you allowed to publish? Similarly, again, a collaboration agreement is a bit more of a formalized relationship. So this is when two or more parties are actively working on a project together. So this might be you've received some funding and you're working collaboratively with another university. And so this agreement will govern, again, things like who owns what intellectual property going into the project, who will own what IP coming out of the project. There'll be confidentiality obligations in there and terms relating to kind of publications and who also actually can commercialize these results. And one other one that you might come across quite a lot is funding agreements. So this is if you've received money, say, from UKRI, so a research council, government, a charity or industry. And essentially when they award you with money for a project, they might provide you with a set of terms and conditions relating to that research. So here at Cardiff University, and similarly across all other institutions, there will be a sort of designated research contracts team within your institution, and they are basically responsible for putting together these agreements, whichever they might be, and sort of deciding which is the most appropriate agreement for you. So if you're ever thinking about disclosing any information which you think might be confidential, or you're working with another institution, I would definitely get in touch with your legal department to see if they can put these agreements in place for you. Okay, so we're finally now moving on to the types of intellectual property that you might come across during your research. And one of the main ones I would say is probably a patent. So you probably have heard of patents in the past, but essentially a patent can cover something like a new drug entity, a new mechanistic process, new diagnostic tests, new sort of therapies in general. And basically a patent is a deal between a government and an inventor. So in return for the government giving you monopoly or protection on your research for up to 20 years, you as the inventor have to fully disclose how your research works. So if this is a new drug, you have to disclose, what signaling pathway perhaps that targets, if it's, the new structure of the drug, and how it brings about this therapeutic effect that you're saying it does. And as I said, patents are valid for up to 20 years, as long as you pay the maintenance fees. And patent protection is territorial, so you actually get to select where you want your patent to be protected and be effective in. So the one thing about a patent, it is a little bit strange, is that it is a negative right. So what this essentially means is, if you have a patent on perhaps your new cell therapy, it doesn't give you the right to use that cell therapy and going forward. But what it does do, it gives you permission to prevent other people from using your cell therapy without your permission. So in order to get a patent granted and have a patent in force, there needs to be kind of three main criteria that you have to hit in order for, to actually get it granted. So this needs to be novel, it needs to be inventive, and it needs to be commercially applicable. So obviously in the first instance, we have novelty. So obviously it needs to be something new, and it needs to be an improvement over existing technology. And what we say is as well, even if so a lot of researchers know it needs to be novel against perhaps competitor groups. But what people don't realize as well is, if you actually disclose your own work yourself, so perhaps submit an abstract for a conference or a paper, that actually is disclosing your work. And it'll count against you essentially, even though you've done it yourself. So what we always try to say is, if you are looking to file a patent, you do have to keep the invention or your idea, what we say, a secret before you file the patent application, to maintain this novelty aspect. But I mean, obviously all institutions know that there might be instances where you do have to share your information with other, universities or a commercial partner. And obviously this comes back now to these agreements. So we always say, if this is the case, you must put one of these NDAs or CDAs in place, so that this, the novelty aspect is maintained, because these conversations were confidential. So what we always say is, disclosures count against you, even if you disclose yourself. So we always say, patent your work first and then publish after. So this second criteria is that the patent needs to be inventive. So what this essentially means, it must be a non-obvious improvement over what is already existing. So there needs to be some kind of imagination or innovation involved in the development of your research. And what we would generally say is, if someone who is an expert in the field or skilled in the art, so this is someone who is an expert in perhaps cell therapies in a certain field, we would say, if they took into consideration all probably available knowledge at that time on that certain topic, so gathered together all the current papers, any patent filings, and if they thought it was obvious bringing together all of this information, then it wouldn't be seen as kind of inventive. As I said, it needs to have that step change in what is currently being done. And finally then, patents do need to be commercially applicable. So what this essentially means is, there needs to be a market for whatever it is that you're developing. So if you're developing a cell therapy, and I mean, the area that you guys are working in, there is going to be a market for any therapies that you might develop, or research tools that you might develop. But just to show that obviously commercial applicability is really important, because it's kind of always known as the one that people kind of forget about. So what we say is, in front of me here is what is referred to as a high five machine. And essentially, there was a guy who lived out in America, and he loved watching baseball with his friends. And, if they got a home run, high fives all around, celebrations. But he was watching baseball alone one day, and, he had no one to high five. And he said, wouldn't it be great if there was a high five machine that I could use? So where number 16 is, so this is a hard surface. So essentially it's a mechanical hand with a sensor, that when the human aspect of it raised the hand in a high five motion, the mechanical hand would pick up the sensor. It's obviously affixed to a certain height on a hard surface. And the sensor would pick up the movement from the human. It would retract the mechanical arm and launch it forward in a high five motion. And so this was his high five machine. It was definitely novel, because no one had ever done it before. It was definitely inventive, because I don't think anyone had ever suggested or said about doing this before. But was it really commercially applicable? Do you think that many people would actually want to buy this device? And as such, it wasn't. And this patent was actually withdrawn shortly after. But it just goes to show, really, you do need to have a market. for your product. And I mean, some of you might be working on rare diseases. That does still count as a market because there is a significant market there. And actually rare diseases is quite a renowned market as well. So yeah, it's just something to think about, that your patent does need to hit the 3 criteria. So novelty, inventiveness, and commercial applicability. So I told you what you can actually patent, but what or are there any patent exclusions essentially? So you can't patent any scientific theories or mathematical models or programs for computers, which are classed as coding, because these are seen as more of copyright, except unless you have a technical effect, unless the code has a technical effect. So what this means is the code has to actually do something, bring about a change in something, coding, patents for coding is quite a difficult area. So we work quite closely with our patent attorneys to figure out if any of the software that we do generate would be classed as patentable subject matter or copyright. So what you also can't patent are immoral or antisocial subject matters. And for the UK IPO or Intellectual Property Office hasn't ever actually fully disclosed or explicitly said what they refer to as immoral or antisocial. But I'm sure if anyone did submit anything, you'd kind of soon know about it if they thought it fell into this category. And what you also can't do now is you can't patent naturally occurring plant and animal varieties, including some DNA or genes. And finally, then, you can't actually patent a method of medical treatment. So what a method of medical treatment is, so say you developed a new cell therapy and you knew if you administer it to the patient 3 times in, say, at certain time points during their treatment block, that worked more effectively than giving a one-off kind of dose. That would be referred to as a method of medical treatment. And as I said, in Europe, and I don't actually know the reason why, but in Europe that is not allowed. But in other territories such as the US, Australia, China, Japan, they do allow these methods of medical treatment. So as a university at Cardiff, and I'm sure your institutions do the same, if any of our researchers do have a method of medical treatment that goes alongside their patent filing, we do always include this in our patents, but we know it's going to get knocked out for the European filing, but it's there for the countries that do allow such sort of claims. So this is obviously quite a Cardiff-centric sort of process. So what I'm explaining to you now is the process for if you thought you had something which might be patentable, what you essentially do about it. So here at Cardiff University, and I speak to a lot of my counterparts in other universities, and it is a very similar process, but you might want to sort of look at your intranet pages or speak with an equivalent of myself within your institution to find out actually what this process actually is. But essentially what we do here at Cardiff is, well, pre-COVID, we used to actually physically meet with different sort of inventors or researchers. And what we would get them to do is sort of, we'd have a meeting about their research, and I'd get them to fill out what we refer to here at Cardiff as a technology disclosure form. But essentially all this really is, it gives the academic a chance to sort of describe their invention or their research in their own words, really, and we have a record of that. And all institutions will do then what they refer to as their due diligence checks. So this is when you're looking, does this research hit those 3 criteria, the inventiveness, the novelty, and the commercial applicability? And here at Cardiff, if I think, or my colleagues think, this bit of research that you have conducted does fall under this category, what we would then do is invite you to our commercial advisory panel. And as I said, I have heard that other universities do have a similar kind of setup. And what this commercial advisory panel is, it's made up of internal and external people who are experts in, commercializing research, patent attorneys, market experts, people who have set up business companies based on research. And this is all under a confidentiality, so there are no disclosures here. And they will give us indications as to whether or not we should proceed with filing a patent on this work. And if we do, what is referred to as the first sort of patent filing is the UK provisional patent filing. And this is what I mentioned, it's filed with the UK Patent Office. And this is the receipt I mentioned. So they'll come back to you and say, as of date X, Y, and Z, you developed this invention or this, new drug, new therapy, whatever it is that you have done. And that will give you what is referred to as a priority date. So this will be the date that your research, started, even though you've probably already been working on it for a good couple of years. And what happens then? Within the next 12 months, you have to file a PCT application or an international application with the European Patent Office. And at month 30, so 30 months after the UK provisional, you have to designate what specific territories you want to have your patent sort of protection in. And where you pick your territories is all really dependent on what your research actually is. So just as an example, if you developed a new, rapid diagnostic test for C. difficile, you want to look at what countries have the highest rates of C. difficile infection, and you would want to protect in those territories. So for cell and gene therapies, you normally go for countries like North America, so US, Europe, China and Japan, because they are very big in these fields, Australia. So as I said, it all is dependent really on what your research is and sort of what field it's in. And people like myself will help advise as to where perhaps you might need that patent protection. And at some point during this process, perhaps year 4 or 5, but can be sooner or later, you hope that the patent gets granted. And then you have it in effect for up to that 20 years, but the 20-year timeline obviously started on that UK provisional date. So that is the whole patent timeline as such. But obviously in between each stage, there are multiple rounds of examinations. So patent examiners will review the claims that you have submitted and say, I don't think it's inventive because of this reason. I don't think it's novel because of this reason. And you have to counter argue with them in order to sort of keep your claims as they are. So obviously this is quite an expensive process. So a UK provisional patent application is probably around about £5,000, not including fees for patent attorneys. PCT application can be 7,000 to 10,000, depending. National phase, depending on how many territories you pick, it could be in excess of 25,000. And then obviously if your patent gets granted, you have to pay for it to be granted. And then you have to pay to keep the patent in force for up to that 20 years. So I'm sure all universities have the same process in that we don't have unlimited budgets, obviously, to support every single patent filing for 20 years. So we frequently meet with our commercial advisory panel, and we will discuss ongoing projects as well. And unfortunately, sometimes patents are allowed to lapse, perhaps because there's been no progress or the inventor has kind of moved on to a different sort of field. And that will be the same within all of your universities. So as I said, I think it'd be a good idea if you sort of familiarize yourself with any processes that they have, just so that you're aware of it for if or when you get to that point, you know what you have to do and who you can speak to. So just to show that patents are they're written in a very specific way. So it's legal language, but science legal, which is even harder. And essentially, I don't know if any of you have ever read a patent application or the claims that come within that, but I just want you to have a little look at the claims. So this is a claim set on a patent filing. And I just want you to give it a quick read. And I know you can't refer back to me now, but if you just have a think about what you think it might actually be. And this just goes to show really that patents are written, as I said, in this very specific way, and they're deliberately ambiguous, so that potential competitors, can't really figure out if it's related to their work or not. It's just a difficult claim set to understand really, and I sometimes have to read patents twice to sort of get the gist of what they're actually claiming. So just to show you what this one is, so this is actually the patent for manufacturing of aero. So as you can see in the claim set here, so it's edible fatty medium, i.e. the chocolate. And what they say then is that the process for making the bubbles within the aero is essentially they obviously heat the chocolate to a molten state. Then they change the sort of pressure and the temperature. So lower the temperature, increase the pressure to form these bubbles. And obviously, as they keep lowering the temperature, they essentially set. And obviously, it's under very specific kind of temperatures and that kind of thing. So they actually patented this process. But as you can see, it's just really difficult to actually understand that that's what they're kind of getting at here. So that's why people like myself and patent attorneys are here to help you kind of understand this. So we're all done with patents, but I just want to go over a couple of other kind of types of intellectual property that you might come across. So I'm sure you're all aware of what copyright is. As we mentioned earlier, it's one of these automatically generated types of intellectual property. So it protects the expression of the idea, but not the actual idea itself. So it's something tangible, which is written down or nowadays, obviously, on a computer. And you all know this will be things like any posters or abstracts for conferences that you do, any sort of papers as well. And as we said, coding generally falls under the copyright umbrella. But this might also include new protocols or questionnaires. So if you have any patient-related questionnaires or new protocols for, say, differentiating iPSCs or something like that. So everyone will recognise that C within the circle, and that is the sort of indication that copyright is held by someone. So me, obviously I work for Cardiff University, I've developed these slides. So technically I could have put copyright symbol, Cardiff University 2021, because my IP is owned by Cardiff University. And just a sort of note as well, so copyright actually lasts for the lifetime of whoever is classed as the author, so whoever came up with that piece of copyright, and then an additional 70 years following their death. So next up, we have what's referred to as design rights. So essentially, this is what something looks like. And again, like in patents, it needs to be original, new, novel. You cannot be copying what someone else has done. And you might want to get a design right, say, perhaps on, say you've generated a new microneedle for the delivery of your new cell therapy. And you know that a certain configuration of microneedles, perhaps is a concentric design, that would be your design rights. You might also be able to get a patent on it, but perhaps you want to protect the actual design as well. So as I said, it might be that they're concentric microneedles, or there's a certain number on the sort of palids, which are the squares there. And that could be something which you could get design rights on. So essentially, design rights will last for 25 years from filing it if you have a registered design right. And that is as long as you pay a renewal fee every 5 years. But as we said, you can have those unregistered design rights, which are automatically generated. And also, you don't need to sort of go out of your way to file them. So it all depends on what you want. So next up, we have trademarks. So trademarks are an indication of origin. So it's how you distinguish, say, your company or your goods from that of someone else. So it's essentially, you know, your kind of your logo, your shape that's associated with your brand. But what trademarks can't do is they cannot describe the product. So you couldn't trademark the word kind of sellotape, because that it is what it is, if that makes sense. So trademarks, if you have a registered trademark, so again, if you file a trademark, this can last basically for as long as you want, as long as you pay a renewal fee every 10 years on that trademark. And then obviously the unregistered ones are unregistered anyway. And the difference that you can see, and it's shown quite well in these two, I don't know if you can see it, but above the Sigma, so above the Sigma Aldrich kind of like logo, there's a little R within a circle. Sorry, it's absolutely tiny. But the R within the circle means that it is a registered trademark. So Sigma Aldrich, they have registered their trademark, which they're using as essentially their logo. So then you can see this Pro 10 TM. Some of you might be aware of this. So it's the AskBio Hex293 cell line, which is used to obviously generate high yield ABV vectors. So Pro 10, the TM there, that means it is an unregistered trademark. So the name of that cell line is Pro TM, not registered. So yeah, that is essentially trademarks. All of your institutions will have trademarked. So as at Cardiff University, top left-hand corner there, that's our trademark essentially. And all your universities and institutions will have done the same as well. And sort of the last type of intellectual property that I just wanted to quickly mention to you is what we refer to as confidential information or trade secrets. So this is something which is important to you as a researcher or a company in order to, conduct your research, but you don't want that information to be in the public domain. And this might be because it doesn't quite fit into a patent filing or any of the other types of intellectual property, or because patents, you have to fully disclose how your invention works. Perhaps you don't want anyone to know that either, so you maintain monopoly over your research. And as I said, then that is what is referred to as your know-how, trade secrets, confidential information. So this is a different one, and again, an unregistered type of intellectual property. So you don't have to register it, but obviously, if your way of protecting that is just by not telling people, there is a chance that that information can get out into the public domain. And once it is, you don't have any sort of formal intellectual property rights on that. So one really good generic example is that of KFC. So KFC actually, so the breaded kind of crumb mixture, wherever you want to refer it to as, so that is actually a trade secret from KFC. So KFC have 11 little vials in a safe or a vault within KFC headquarters in Kentucky, US. And that has got the 11 vials of each of the herbs and spices and obviously the full recipe. So they've kept this as a trade secret. So you might know what herbs they are, but you don't know in what quantities and how it's actually mixed. And the way they've done this is kept it as a trade secret. So how they've done this is they've limited the number of people that are actually aware of the full recipe, including their manufacturers. So actually what they do is they outsource the mix as such to 2 different companies. So one company does 6 of the herbs and spices and another company does the other 5. So neither of the manufacturers know the full recipe. So obviously, and I think the only indication that we have is if you go on Twitter, they follow the 5 Spice Girls and 6 men called herbs. So that's their indication that it is 5 spices and 6 herbs. But I mean, for you lot doing your research, this might be, say you've developed a new media, which actually allows you to differentiate your neurons better. Or you have a new process whereby, at a certain temperature and a certain pressure, perhaps, that facilitates more functional neuron development from when you're differentiating them. That would be your know-how and something that perhaps you didn't want the world to kind of know. So again, just as a generic example, so one product can have multiple different types of intellectual property associated with it. So this might be, so Coca-Cola is a massive example of this, trade secrets on their recipes, patents, copyright, they've got everything, but they have the money available to be able to do that. But a good example, like we mentioned earlier, might have been that microneedle. So you might have had a patent on the use of microneedles to deliver, say, a cell therapy or a new vaccine. And there might be a patent on that overall. You might have design rights on the actual microneedle and configuration of that. You might have, say you had dissolvable microneedles within that, and it's a polymer. You might have a trade secret on the actual polymer constitution. You could have a trademark, and you could have copyright of branding, that kind of thing. So yeah, one product can have multiple different types of intellectual property. And I just wanted to finish up on what we refer to as infringement. So infringement is essentially when you use someone else's intellectual property without their permission. And then on the flip side, if someone uses your intellectual property without your permission. So essentially, you're not getting permission to use someone's IP. And one really sort of generic example of this is of, you might have seen these images previously a couple of years ago, they did go viral. So David Slater was a wildlife photographer. He was really interested in these certain type of monkeys. So he went out to Indonesia to sort of take pictures of these monkeys. And he when he was taking the images, the monkeys knew he was there, and he said that, you know, they weren't acting naturally. So he set up a scenario whereby he put a tripod in, set the camera up, and the monkeys were obviously really inquisitive, and they sort of came over to the cameras, and they essentially ended up taking a load of selfies. And obviously, when he came back to collect his camera, he thought this was amazing. And, you know, he thought, I'm going to have, you know, front cover on Nature magazine next month. You know, this is great. So he started approaching different sort of journals for access to these images through a license. But somehow Wikimedia got access to these images, and they uploaded them all to Wikimedia. So David Slater said, hang on, I didn't give you permission to use these images on your website, take them down. So David Slater, so this is infringement case number 1, David Slater took Wikimedia.com to court, but they've never actually, I think, resolved that situation because the images are still available there. But then a couple of years later, so the animal rights company, PETA, they then got in touch with David Slater, and they said this was infringement case number 2. They said David Slater didn't take the images themselves, the monkeys did. Therefore, the monkey owned the copyright, and David Slater was generating income using these images, you know, when the monkeys it's their copyright. So it's infringement of them. So this one, also, this sort of case also went to court. And basically, this one did get resolved, took a couple of years, got resolved in about 2018. And this one, the court ruled that obviously the monkeys were non-human and they couldn't own their own copyright. And that they said that David, you know, actively set up that situation to enable these images to be taken. And they said, therefore, that the copyright lay with David Slater. But they then did say to him, you know, any money you make off these images, in what 25% of that every year needs to be paid to a specific charity that looks after these monkeys. So obviously, this is just a bit of a silly kind of example, but it just goes to show really, if you do infringe someone's copyright, there is a chance that they could take you to court essentially. So you always need to make sure you have the necessary permissions to use other people's work before you actually do it. And as I said, there were 2 infringement sort of scenarios in this one. Obviously, it was found that David Slater wasn't infringing. But as I said, it's just really important to make sure you have this permission. Okay, just to sort of finish up, we're just looking at what we refer to as this technology transfer process. So this is essentially sometimes referred to as translation. So essentially what, I guess, the textbook definition of this is it's the process of translating an idea or IP or a product into a commercially viable product or process which meets a defined market need. So what this essentially means is you're taking fundamental research, which is being carried out by you as, you know, university, and you're developing it right to the point whereby, and in your case, you're actually delivering stem cell therapies to patients. So it's been adopted into a wider healthcare setting. So why would you go down this technology transfer or translation route? You know, why wouldn't you just stick to fundamental blue skies research? And obviously here, it brings a sense of real world relevance to you. So if you knew that, you know, perhaps you might be stuck in doing ELISAs all day, but if you knew how that linked and how that could actually impact and benefit perhaps a patient in the future, gives a bit more of, I think, an incentive and links it back to, you know, what your research can actually achieve. I'm sure you've all heard of REF, or Research Excellence Framework. Impact is a massive thing at the moment, and translating your research is an impact essentially. So you might pick up new collaborations that perhaps you hadn't thought of doing before. And obviously the end goal is, in a way, that you hope you'll generate some income or potentially create more opportunities for employment. And I think this sort of diagram just quite nicely shows the kind of process of translation or technology transfer. So essentially, there's 3 kind of columns as such for me. So you've got the research column, which is down on the left-hand side. So this is where you guys fall in as researchers. So you are conducting the research, you are generating the intellectual property, and you are doing the hard graph part of it. We then move across to this tech transfer kind of part of it. So this is where myself and obviously counterpart colleagues in other universities fall in. So what we do is we identify any intellectual property, help protect it, and help commercialize that, intellectual property. And that falls into that last column there, is that we help, identify by what route is most appropriate for you to commercialize your research, whether that is through licensing or spinning out. And the reason why we commercialize the research, again, is to get it to that point where it is adopted as a new therapy or, in a healthcare setting. So who can actually help me? So as I said, I'm a technology transfer officer. That is my job title. I guess my team is called the Research, Commercialisation and Impact Team, and I fall under Research and Innovation Services Department within the university. So there's quite a lot of terms there. You will have colleagues within your own institutions which essentially do a similar or the same job as myself. So you might hear your department being called something like Research and Innovation Services, Innovation and Enterprise Offices, commercialization offices. And you might refer to people like myself. They might be a technology transfer officer like me, sometimes referred to as knowledge exchange officers or IP or innovation managers. So there are people out there that can help you. And as I said, I would definitely have a little check on your intranet pages to figure out who exactly it is that you would go to for assistance with this. And obviously people like myself and the counterparties in your universities, what we do is we're responsible for the identification, protection and commercialization of the university's research base. So as I said previously, what I would go and do, I'd meet with different academics, learn about their research and technologies, try then and protect any intellectual property if there is any to protect, and obviously file and maintain that. We also help people sort of with translational funding. So where can they go to get their next kind of round of funding? And as I said, then we will always help you identify and try it and get your research out there in the public sector. So we identify which route is the most appropriate for you and your sort of specific research. So what we would do is, say you'd come to me as a researcher, what we've done is we've managed to protect perhaps say your work via a patent application, say, and then, we don't just help with that bit and then we kind of leave you to it. What we would then do is we sort of work with you to try and, as I said, translate this research. So I'd be saying to you, have you reduced the invention to practice? So what this essentially means is, are you able to show what you're saying your research is doing? Have you got proof of concept? What research you need to do in order to take this forward? Do you need to make prototypes? How much testing do you need to do? And where are you going to get the money from? Are you going to go for a research council, industry, that kind of thing? And what do you actually need to do to get your idea implemented into the healthcare setting? So if it's a new drug, you need to get the relevant sort of FDA or MHRA approvals. If it's something like a medical device, you need to do CE marking and MHRA as well. So we help try and identify, how you're going to be able to take your research forward. And what we always kind of get people to do is think of realistic timelines, what your realistic milestones are, what your key deliverables are, because these are things that potentially an investor will want to know about. So we said one way that you can commercialize your research is through what we refer to as a licensing deal. And this is when we explicitly give a company permission to use your IP in return for a payment. So this is, you're giving someone permission, so this is not infringement. So licenses even can be exclusive or non-exclusive. So what this means is if you have an exclusive license to someone, it will be to one company only. Or if you have a non-exclusive license, you can perhaps license to multiple parties at one time. And what we always say is if you are going down this licensing route, you generally license to a company who is already established in the same field that you're already in. So it'd be if you generated, some new antibodies as a research tool. So perhaps as a tool to do translational research, you perhaps want to go to someone like Millipore, Sigma, who sell reagents frequently. Or if you've done something like developing a new drug entity, a new cell therapy, you want them to go to companies that can actually take these forward. And what we sometimes say is that it's kind of at arm's length. So the academic will develop it to a certain point, And then you kind of give control over to that company who might do the clinical trial work, you know, and then is responsible for exploitation. And then the other kind of route that we might go down is through the formation of what we refer to as a spin-out company. So this is when you form a brand new company specifically for the reason of exploiting this specific technology. So this might be when it's a bit of a disruptive technology, so there's a little existing market. So this would be perhaps when there's not one clear company who you think you could take this forward. And inventors sometimes have a bit more control because obviously they're more involved in the sort of commercial side of this research. But just to kind of caveat that, obviously, it takes a massive amount of time and everything on the inventor. So it can be quite stressful for them, actually. And what we always say is that what makes a good spin-out company? So the inventor needs to be quite motivated. You need to have shown proof of concept. As I said, it might be a disruptive market to begin with, but there does need to be an eventual market for your technology. You need to have strong IP position. And as I said, you need this clear kind of route to market and a believable business model. And one quite good example is a spin-out company from UCL, so University College London, and this is Glialine. And this was established, I think, in 2018. And essentially, it is a treatment for sort of peripheral nerve injury. And what they have done is they've sort of developed, it's called engineered neural tissue. So it provides kind of like a structure for neurons to be grown on to enable kind of functional recovery. And obviously, that is one of the spin-outs from UCL. And as I said, you know, they had all of those criteria that we're seeing on the screen now, and that will ensure that the company then is a success. So all universities, as much as they love to say they have loads of spin-out companies, they probably want to look for quality rather than quantity. So you can't just go setting up a company as you wish. Here in Cardiff University, we do have, you know, a procedure in place whereby approvals need to be obtained from our executive board in order to set up the company. And I'm sure that is the same in your institutions as well. So as I said, it's really worthwhile having a discussion with the relevant research office within your university. So that is everything from me. So it was a very one-stop shop of intellectual property in a nutshell. So apologies, there's a lot of information at once. But what I really wanted to kind of you to take away is that obviously IP isn't just for industrial-based work. What I used to hear a lot of is, oh, IP is just for companies. No, it definitely is not. So you will always be generating intellectual property. And it's a really good idea, as I said, to capitalize on that. And, you know, if we're looking at patents, we always want to make sure that we're keeping those 3 criteria. So the novelty aspect. So we always say, make sure you patent and then publish. And as I said, you're wanting to make sure you're aware of who the inventors of the technology are. So we need to make sure we have the appropriate agreements in place for collaborative work. And then sort of finally, obviously, exploiting IP is, you know, it can be a lengthy process. It's very rewarding. And obviously the type or how you commercialize your research is really dependent on what your research actually is. And as I said, speak to people like myself and we can help advise how is best for you to sort of proceed in that way. So yeah, that is everything from me this morning. As I said, apologies, a very quick overview. If you have any questions, and I think Carly was monitoring some kind of forum for that.
Yeah, absolutely. Thank you very much, Rhian. That was really interesting. There were so many things in there that I myself didn't know, so I'm sure a lot of the audience were learning a lot there too. I think you really covered the basics of IP in kind of a way that we can understand using sort of real world examples, both from the gene and cell therapy field, but also from outside of the field, like KFC and Coca-Cola. They're all brands that we can relate to. So yeah, I think that was really clear and has kind of broken it down in an area that actually as academics we find quite daunting to sort of approach this tech transfer. So yeah, I think that was really great. I'll just jump to the questions. So we have quite a few questions that have come in. So the first one is from Ala Siam, and they have asked 2 questions actually. The first one is, can you patent a computational model of a drug during in silico design phase? So I guess you touched on this there has to be sort of a translational component, a downstream effect to be able to patent a computational model. Is that correct?
It depends really. If it's a computational model, is it going to be then reduced to practice? So is it going to actually become a physical product, not just a product on kind of screen? Obviously, I guess that's something you need to take into consideration. And I think you need to look at it in a bit more kind of detail in terms of, what the model kind of actually does. In order to give a sort of fuller answer, I'm afraid. But I don't know what institution they belong to.
They've not mentioned it. They might put it through on the chat now you're answering. So if Al-Siam can put your institution, we can mention that to Rhian.
All I was going to say is that I think this is one of the prime examples where I think you probably should have a chat with the equivalent of my roles within your institution, and they will be able to kind of look into that for you in a bit more detail. And once if you know either way, obviously that might inform how your research kind of progresses in going forward. So yeah, I definitely do that.
Okay, and I think they had a second part to the question. So during the patent application, so from PCT to it being granted, can you publish your research in that period, or do you have to wait till the very end till it is granted?
No. So what we generally say is that so once you file your UK provisional patent application, so that is that day zero, within that year, then you file that PCT application. And 6 months following that, your PCT application will publish. So it will become publicly available knowledge. And, people will publish their work then. But one of the other sort of points that I definitely speak to your relevant officers about this as well, so they're aware of timelines and everything. Because what we quite often do, as long as you file that UK provisional patent application and you have that priority date, you can publish kind of straight away, but it all kind of depends on strategy. So it might be if your publication adds in more data, you might want to wait until you filed that second application before you publish. So it's all about timing, and I'm sure other sort of colleagues in other institutions will say the same thing. It's not that we're saying you cannot publish for 4 years, that isn't the case. It's just you need to be kind of selective and make the officers aware so they know what you are and not able to kind of include in publications. Mm-hmm.
So they've actually come back and said they're at UCL and they're referring to results of a virtual screening for drugs. So actually it kind of sounds like they do need to contact your sort of counterpart at UCL and have that discussion and start the ball rolling.
Yeah, I think Sarah, there's someone called Sarah. Sorry, that's not very helpful at all, is it really? A massive university like that. But there is an equivalent office of mine there, and we definitely spoke with them recently. So yeah, definitely get in touch with them, because obviously if the idea is, if you're I'm guessing you're doing drug design, and then I guess the idea is you will produce a hit compound which you will generate at some point. So yeah, that's definitely something you can patent then. Obviously, as long as it hits the kind of novelty aspect of it, and I'm guessing if you're designing a drug from scratch, potentially that could be the case. So yeah, get in touch with the research team there, and I'm sure they'd be able to kind of give you some advice on what you're able to do.
Okay, that's great. I'm sure that's really helpful. So the next question is from Robin Bell at Imperial, and she has asked, is there an element of subjectivity when assessing the inventiveness step that you mentioned as one of the key steps? And if so, how is this controlled for? I guess, how is that
accounted for? Yeah. So I mean, when I was explaining the kind of process, it seems a lot more simple than it actually is, but it is quite, a very back and forth iterative process. So obviously we will get a patent attorney to assess the work. So we get the inventor to fill out that form, explain of competitors that they're aware of, or work that other people are doing in this area. And as I said, then we will look then to see if we can show that our work is novel and inventive. And as I said, the attorney will provide a lot of advice for this. So we will file claims that we know don't sort of cross with anyone else's. And as you said, then obviously, as you're going through that process, then you do have basically arguments with an examiner via letter, and they will say to you, we don't believe it's inventive because we've seen this document, which is a paper that person X, submitted 5 years ago. this bit, we think this bit of your work isn't inventive because of this reason. And then you provide your counter arguments then written, well, the attorney does it anyway, as to why you believe that your work is inventive against what they have said. So obviously there is a degree of subjectivity, but I think what we do is we provide enough evidence to show that we believe it is inventive, and obviously submit all of those to the examiner for them to re-review and sort of consider again.
So this is more of a process back and forth as opposed to just dumping all of the information. It seems to be more of a crosstalk back and forward where you can sort of have almost a rebuttal of what's being said and what progress is being made. Yeah, so obviously, as I said, we had those kind of time points, and that is where you file an application. But then in the interim for that year, in the interim for the other 18 months, you know, it's just that there are these discussions back and forth between examiners, and they all say, we've looked at all of the prior art available, and as I said, we don't think it's novel or inventive because of this reason. Explain to us why you think it is. So it is very iterative, and sometimes we might have to slightly tweak what we have claimed because perhaps we can't get around some prior art. But that's why it's quite important to have quite a good relationship, I think, with your attorney, patent attorney, because they will know how is best to deal with these situations and how best to counter argue and rebut back. And there's quite a few times, particularly when you get to national phase, that's when the rebuttal kind of starts essentially. We've had 4 rebuttals back and forth for one filing before in Europe. So yeah, very iterative, can be subjective, but yeah, I have to speak to the attorneys and you know, they have best say on how you respond to them. Cool, great. Okay, so the next question is coming from Rebecca Gill, who is at Royal Holloway in London. And I think she's sort of touching upon some of the exemptions or things that you can't put a patent on. So she's asked, what is the current situation with genetically modified organisms? She thinks there's a way to patent them in the US, but is it the same in Europe and in the UK, or is that a bit of a grey area? I was going to say it's a bit of a grey area, and I'm probably not, because it's more to do with patent law. It's probably a question more for an attorney to look at, because they all look at it from the legal side of things as to what you can and cannot do. There probably are ways around doing it. As I said, I think, sorry, it's not the most helpful answer. But again, I think because research is so specific to each person or each project, you kind of have to know a lot of information of the background to be able to kind of give quite a helpful answer. But as I said, more of a legal answer is probably best for you on that occasion, sorry. But yeah, it's something to look into, I would have thought. Okay, she's also got a second question. Yeah. That's probably much more of a clear-cut question. You mentioned the fees for applying for a patent, and she's just asking what the yearly fees are to maintain a patent and whether they vary per country or how many countries you're including on that patent. Yeah, so yeah, that's definitely correct. So obviously when you get to national phase, then renewals kind of start kicking in for certain countries. Some countries you don't have to pay renewals until you grant, and obviously again this is something that the attorneys would sort out on your behalf. But essentially, as with everything, every kind of year your patent maintains, you know, its protection. The fee does go up every year, so it does get a little bit more expensive, and like you said, you know, countries vary in costings as well. US and Europe are probably on the larger kind of side of things. And some of the other countries perhaps are a little bit less. But as I said, there is an incremental increase in price up to that 20-year mark, which is why you quite often need to sift out, you know, what projects are actually progressing. And it's quite often the case as well in Europe, when you get your patent granted in Europe, because basically that gives you a gateway to Europe, but then you have to designate specific countries within Europe you want to have your protection. So whether you want that to be UK, France, Germany, wherever you want to go essentially. And obviously the more you have, the more expensive it is again. So yeah, it is a very expensive process. I deal with renewals on behalf of Cardiff University. So you've got to keep an eye on everything and make sure everything is renewed. And obviously, as I said, the costings are available to you then. So with it being that costly, are you able to provide guidance on how many, you know, countries or continents should be included in this? Because obviously, as as a researcher, we might not really know whether we want this to be a global pattern or just in one country or just in Europe. So I guess you could provide some guidance on that when people are contacting you.
Yeah, so obviously that's something that kind of comes later down the line. But I mean, that is something that you discuss as the time is sort of coming, because you obviously need to forecast for spend, and all universities would need to do that. But yeah, it's definitely a discussion that we have. We look at what the technology actually is. So as I said, where would you actually need that protection? Where is the key market for your research? So you would definitely need protection in that area. And then some universities perhaps have a slightly larger budget, so they could go, more wider essentially. But yeah, it's something that we can help guide you. And you have to look at the status of the technology as well. So is it actually going to be progressing to a commercial sort of setting? Is there already a commercial partner involved? Because they might want to pay for a larger number of territories to be filed. So yeah, that's all advice and stuff that we can sort of look into and assist with as well.
Oh, that sounds great. So we've got another question come in from Zach Sword at Cardiff University, and he's asked, in the event that an inventor wishes to spin out a company and raise money through venture capital to get the safety and efficacy data of a new therapeutic, what happens to the share allocation of the intellectual property with regards to the university then? So I guess this relates to the breakdown you showed for the inventor and the university and the school.
In a way, it can be slightly different with a company. So essentially, I'm sure it's probably similar in other universities as well. But when the university at Cardiff now forms a spin-out company, it's obviously based on Cardiff intellectual property. Investors will want to have a share, obviously. If they're putting in X amount of money, they're going to want to own X percentage of that company. And then it's up to the university to decide whether or not they want to take shares in that company, or whether perhaps they want to do a slightly different model. And again, it all really depends on what the technology is and what you think is the best way to kind of get money back on that technology. But obviously then the inventor would fall under any income received by the university in that sort of pathway that I mentioned at the beginning. And I said, I'm sure there are similar scenarios in place with all of the other universities as well.
So yeah, that sounds actually, I think he's thinking you were probably going to answer like that. As sort of said, where in that pipeline would the university be happy to sort of have its IP share bought back? Is this very dependent on the specific product or therapy that's being patented, or is there sort of a normal stage in this process where that will happen?
I'm not quite sure what he means by bought back, but essentially it depends how you form a spin-out company, really. So it might be that you form a spin-out company and you assign the intellectual property. So the intellectual property is no longer owned by the university, it's owned by the company. Or it might be that the university retains ownership over it, but gives that permission for the company to use that in going forward. So it really depends on, I think, where the IP lies as well, and obviously what procedures and processes are in place in terms of the forming the spin-out company as well.
Yeah, I think you meant bought out as opposed to bought back, but yeah, that makes sense. Okay, so we've got one final question before we wrap up, and that's again from Robin Bell. Do you have advice for researchers at early stages in their projects to help potential downstream commercialization? Yes, if they're not sure whether their research would be relevant to tech transfer, or should they contact you really early on and just have that discussion and see whether that's a path that they're going down?
Yeah, I mean, definitely. And I've said this and I'll keep saying it again. It's always really, really good idea to get in touch with the Office of Tech Transfer, Research Innovation Services, whatever it's referred to as within your university. I always prefer that someone comes to me early and then I say to them, oh, you're a bit early at the moment, but come back to me, whenever. And I'd much prefer that than someone who has kind of steamed on ahead and then maybe kind of done something which prevents them from being able to commercialize research and going forward. So I'd always much prefer saying to someone, wait a little bit, but I'm really glad you came to me. And you know who you need to contact then. And even if you come to me early, I can say to you then, We think there might be something here, but I think you need a bit more data to actually confirm or prove your concept. But, remember, if you're submitting any papers, do not put in any confidential information which is classed as confidential. Do not make any reference to that. Don't do any, And then quite often we've had someone who, it was about 2 or 3 years before we actually filed a patent from when I first engaged with him. And obviously he used to submit papers on a similar area, and he'd send me the paper beforehand, and I would look at it, speak with an attorney sometimes if needed, and we would remove certain aspects or certain figures of the paper, so that the idea was not disclosed, so we could still do publications while keeping this work that we wanted to patent confidential. And I think you would only be aware of something like that if you engaged with the team quite early, and we can perhaps give you a bit of advice or point out, where you could get some more translational funding from. So yeah, I think my key bit of advice, which I will say to the deaf, is that definitely get in contact with the offices at an early stage, and they'll give you all the help and support you need.
Yeah, I guess that's a really important take home, that actually as researchers, we're not expected to know all of this information. Kind of just having the access to people like you and your teams, actually, it means that we can contact you early on and you could tell us where we are in this pipeline and what we should be doing next. We don't need to know all the information. We just need to be able to follow, the instructions we're being given and follow the pipeline and be able to stick to that. So yeah, I think that's a really key message for everybody to contact their relevant office really early on.
Yeah, I was going to say, we're not experts in the research. That's your job. So what we can do for you is help guide you kind of through that process, and that's our kind of expertise. So they're complementary. So yeah, I definitely make sure that you're getting in touch with someone. As I said, even if it's that they say it's a bit too early, you know who you need to go to when that time comes.
Absolutely. Rhian, thank you so much. I'm going to wrap up the questions there because we just have 1 or 2 minutes left. I'm going to quickly share my screen, which will just promote the next seminar that the BSGCT are running. This is actually a new seminar series that will start in January 2022, and that's the BSGCT Patient and Public Engagement Seminar Series. And the opening seminar in that series will be given by Simon Waddington from UCL. There'll also be another ECR seminar in the spring of 2022, for which we will be promoting, and you'll see through our social media pages closer to the time. So do stay tuned. I'd also like to encourage everyone who's watching to check out the BSGCT website and consider becoming a full member for full access to all our materials and funding. So yeah, check out our BSGCT website and our social media pages. So all that's left for me to say is thank you all very much for tuning in. Thank you especially to those who submitted questions and really engaged with Rhian. And also, again, a very special thanks to you, Rhian, for sharing your expertise and answering those questions, which were actually quite challenging, but answering them so comprehensively and clearly. So thank you very, very much, and goodbye, everybody, until next time.